Today we're down to today we're down to three or four people. Um, so yeah, it's even more intimate than really ever. So feel free to come in and say, hey, over here we do this or whatever. I know you guys are in different markets and you're not really competing with each other. So I think you can feel comfortable and safe in asking questions that might be unique or specific to your business without really feeling that you're offering up any confidential information. I'm going to, we've started recording, so I'm going to flip over to our share screen and sharing is not turned on. Are you still there, um, Jen? So we
Yeah,
can,
I'm here. Just one sec. Okay, there. Give it a try.
uh, perfect. Yeah. Okay, hopefully everyone can see the screen. If you can't see the screen, then jump off your microphone and let me know that you haven't seen it yet. But we talked about the different aspects of the mission statement and six potential courses, five mandatory that must be taken in order to move through to take the challenge exam. We talked a little bit about the challenge exam and how to prepare for it yesterday. And we talked yesterday about the Access Code of Ethics and that your company has made a commitment to the Access Code of Ethics. Today, we're going to talk about human rights, and we're going to talk about the legal aspects of human rights and some of the lingo that is used inside various human rights and how it applies to us in our hiring practices. We're going to talk about some of the other legislations that might affect things like diversity and employment equity and AODA. And we're going to talk about privacy legislation today also and kind of move through all those. And of course, this is in order for us to make a commitment to uphold our obligations to adhere to all of the laws that apply to us. Today, yesterday, a lot of the things we talked about were unique to the recruitment and staffing industry. And today, this is more big picture. We're going to be talking about some things that apply to everybody. They have some unique applications on how they apply to us. And so we'll always try to use examples and talk about them in the context of being a third party employer, somebody who's offsite supplying your employees onto a customer's into a customer's workplace. But the important thing is that we understand the concepts that we're talking about. And again, I keep saying this on each of our sessions. It's not important that you memorize every single thing here. It's more important that you understand the concepts, what level of government that is, who it applies to, where you might be able to look things up and find things. But I'll repeat it again. These things evolve and change. And they evolve and change because of the notion of what we talked about yesterday about common law. Because typically, what happens is a lot of things aren't described perfectly in the legislation. They're described to adhere to or address a certain principle or an aspect of work or work relationships. And then somebody ends up going to court over their contract or over an application of the law, and then the courts take a look at everything on balance, and they make them some decisions, and those decisions basically become the common law. In other words, if the exact same circumstances happen tomorrow, then the judge tomorrow and the lawyers tomorrow would say, hey, let's take a look at a case precedence, a decision that was made yesterday or sometime in the past with the exact same circumstances. This decision has already been made. And so typically in these court cases, they just argue about and talk about facts. What are the facts? Because presumably, once you know the facts and everybody's agreed upon the facts, then you simply apply the law. You don't argue over the law. You argue whether or not these facts apply to that law. And so very often common law then influences the statutes. So they influence our politicians say, hey, let's codify this, let's write it into a statute and make it like written down so it's not just a previous court case, but it's also part of the statutes. So this happens a lot and has happened a lot with human rights. And we're going to give you some examples of how this happened with human rights. So, we just first off from just a high level, instinctively human. By the way, I know we're being recorded, but I want to just say I'm working from home. I have a disabled daughter who is downstairs, and I have a wife downstairs who is being grandma today. And I'm hearing my disabled daughter call me up the stairs. So if you hear calling in the background, it's because grandma's dealing with baby granddaughter while my other daughter is looking for some attention, and I apologize for that. She's a wonderful young lady. Her name's Samantha, and you might hear her in the background. And I just wanted to let you know that there isn't anybody dying or nothing bad is happening back there in case you hear some calling out. So typically with human rights, we look at dignity, respect, and equality are the things that we expect for the way others to treat us and for us to treat others. And so we have the same issues that we had yesterday with respect to the Constitution. The Canadian Constitution is who rules over what. And in the Constitution, we know that those federally regulated industries that we talked about yesterday, they have got the federal human rights legislation that dictates how they're supposed to behave and what laws they're going to follow. And then we've got individual provinces with their own provincial human rights legislation, which for all intents and purposes is almost exactly the same. Covers the same stuff, different wording, sometimes different processes that the province might follow when there's a complaint, and how the commission might work in order to facilitate complaints and what the penalties might be if there is a complaint. But for all intents and purposes, the human rights are kind of defined under the Charter of Rights and Freedoms, and then they're written into the the federal human rights legislation. And then each province has gone about writing their own legislation so that it can work uniquely within the context of their province. So if you're a bank and you're in Ontario, you're federally legislated, you're under the rules of federal legislation. So you would look to the Federal Human Rights Act. And if you're a staffing company and you're provincially legislated, then you would look to your specific province's Provincial Human Rights Act. For all intents and purposes, from this point forward, we're going to treat them all as pretty much the same. Slightly different wording, slightly different approaches, but we've got the Human Rights Act, the Canadian Human Rights Act for federally regulated organizations. We've got the Charter of Rights and Freedoms. We refer to the Charter, which is a part of our Constitution, which kind of guides all the laws of laws about human rights and how people should be treated. And so if there was a charter challenge, that might be because a province is trying to do something or doesn't do something within their Human Rights Act. And so someone might challenge that and say, hey, but according to the Charter of Rights and Freedoms, you got to do this, or you have to do it this way. And so that's the charter, which deals with human rights. And then we've got each of our individual provincial legislations, and they're often called a Human Rights Code or a Human Rights Act. So what do these human rights codes and acts federally and provincially cover? Well, they cover a lot of things outside of human resources. They cover everything from people's access to services and to housing and rental apartments and all kinds of things. But there's specific sections of the human rights codes and acts that apply to employment practices or the practices of employment. So some of those things deal with things like recruitment advertising, the referrals of candidates to employers, about the process of the selection of people and the decisions around promotions and demotions and hiring and firing. There's around training, who gets training, the right to equal access to training, how you decide when training is offered, how wages are set. We talked the other day about employment equity that would have been driven by human rights laws about gender discrimination. So we talk about wages and how they're set. Um, Lots of talk always, especially I'm not so much recently, but I think I think in my mind more of a hot topic between 1980 and 2010. Lots of questions about application forms. Are you allowed to ask that question on the form? Change that question on the form. And then, of course, when we take interviewing classes and lessons and courses, a big part of that is always about what questions are you allowed to ask? And how do you deal with certain circumstances when, say, for example, you're doing behavioral based and someone starts to go into their answer, starting to disclose things that might be in the areas of prohibited grounds, and so they're volunteering information that you wouldn't have asked for and probably don't want to know, or at least you certainly don't want to know on the record and make it part of your decision process. Things like apprenticeships and transfers of employment and any other matter relating to employment, you're going to find some place in a human rights code or a human rights act will give you some guidance around those things. The discrimination in the workplace is usually where we go when we're talking about sorry, I'm just trying to move some of these things around on my screen so that I can see them a little bit better. Usually when we start to hear about topics in the news or discussions, it's about discrimination. So discrimination is an action or a decision that treats a person or a group of people negatively for reasons such as race, age, or disability. We call these reasons that are prohibited grounds for discrimination or prohibited grounds. And there are 11 grounds that are protected under the Canadian Human Rights Act. And then again, each of the provinces has created their own legislation that might provide greater definition or similar definitions, but they work off of the same grounds. So these 11 grounds of discrimination, in other words, areas that we should not discriminate or make choices or treat people negatively for, are race, national or ethnic origin. So some of these terms are very similar, but not exactly the same. Color, religion, age, sex or gender, sexual orientation, marital status, family status, disability, and convictions. Now, I'm going to jump into convictions right away because it's always kind of interesting and confusing and misleading. We are allowed to have criteria that say you have to pass a security check. Federal government has it. There's a whole bunch of issues right now about whether one of the candidates for prime minister has got his security clearance yet. And so, if you needed to have a security clearance in order to do a particular job, they would then find out whether or not you had a criminal conviction, and you could be prohibited from having employment in that job because it's a bona fide occupational requirement. Same thing can go with police background checks for working with children or vulnerable people. So it is not against the law. It is not discriminatory to use a clear and free background from criminal convictions as criteria for a job, so long as they're legitimate criteria for a job. You're not supposed to say, oh, geez, you can't lay sod in that field if you've ever been convicted of not paying your parking tickets or something. I mean, there has to be some relationship between it. Otherwise, you're discriminating against a person's parking violations. But so you have to create a connection. So this deals with a thing called a pardon. So a pardon is a very legal process where the the and a suspended sentence is basically when everything has passed, you've gone past a date that the law says will no longer recognize that conviction that you had in the past. You're now free and clear. It's removed from your record. And a pardon is an act of the courts that literally says we're going to remove that from your record. So we can have grounds for assessing a person's qualifications for a job that may disqualify an individual because of criminal convictions, but we cannot and shall never eliminate them because of a conviction that has been pardoned, because legally that means it didn't happen. I mean, for all intents and purposes, it means it did not happen. We can't count it for anything. So that's the sort of the layman's expression of for which a pardon has not been granted. Now, we talked the other day about, and again, I talked to already today, about how common law and decisions in courts can affect the way that laws are interpreted, and eventually our elected politicians might actually codify or write legislation that is consistent with the decisions that the courts have made. So with respect to LGBT rights, in a decision back in 1995, so a long time, 30 years ago, 30 years ago, in Egan versus Canada, the Supreme Court of Canada held that although sexual orientation was not listed as grounds for discrimination in the section 15.1 of the Charter of Rights and Freedoms, and it was not specifically listed in the human rights legislation, that the court held that, and in a similar case, this Friend versus Alberta in 1998, so around the same time, they looked at their section of their human rights code and they said, it seems like sexual orientation has got a lot of similarities in its context to sex or gender. And so, and to marital status and to family status. And so they looked at it and said, I don't think that when people wrote this, they really took into consideration the fact that LGBTQ individuals might be discriminated against, when the courts decided it's pretty much always the same thing. And so the courts then went about in 2005 and enacted this thing called the Civil Marriage Act, which basically said that if a same-sex couple is living together and acting like they're married, the same as a heterosexual couple is acting together as if they're married, and that they can be considered in a civil marriage, then in common law or common law marriage, that we can also treat same-sex couples in the same way, that they are married. So this was a decision made by the courts in 95, and then again provincially in 98, and then 7 years later, or 10 years later in the case of the first case, the government finally came around and said, let's write this right into the law, codify it. And so the Civil Marriage Act came about. So that's another example of how common law can affect statute. So let's talk about some terms that are used with respect to discrimination. Look at these 11 areas people are not to be discriminated against for. And then we talk about different types of discrimination. So the first is adverse effect discrimination. So sometimes a corporation or an organization or government has a policy or practice that can unintentionally single out a person or a particular small group of people that has a result that was not intended. So they went about saying, "Oh, here's a policy about this thing," and at the end of the day, somebody says, "Yeah, that doesn't work for me. Like, I understand why it's here. It seems to be like a pretty decent policy about our safety, or about our health, or about our benefits, or about something, or about our equipment, but that doesn't work for me because I've got this unique circumstance that is one of these 11 areas of prohibited grounds." So this is a type of unintentional discrimination, and we call it adverse discrimination. So some things like adverse discrimination might be things like having a uniform in the company, but the uniform conflicts with a person's religious clothing, that they're required to wear some headdress or some piece of religious clothing. And by the way, this goes on even today. In the province of Quebec, there's this ongoing battle about the provincial government not allowing people to wear religious symbols in terms of jewelry and clothing. And it keeps going to court, and the federal government says, no, we're going to, stick our nose in this and butt into the province's business. So this has been going on for years. Um, there, and there's another example, could be establishing a work schedule so that it rotates, 1 week on days, 1 week afternoons, next week evenings, 1 week days, 1 week afternoons, 1 week. And all of a sudden, or that work 4 days in a row, and then you have 3 days off, then you 2 days off, then you work 4 days in a row, and you have 2 days off. And that means that maybe you've got to work on a Sunday or a Friday or on your Sabbath or on a religious holiday that may not be the religious holidays or religious times that a particular person or a particular group might um, adhere to. I don't know if you can see that, but I've got something popping up on my screen here that says, apologies, got to get that out of the way. And so these are another thing, for example, is, at one point in time, I had 32 offices across Canada, and we found it very fair to purchase the exact same furniture from the same vendor. It was less expensive. We could design offices. Everybody felt the same when they went from one office to the other. Wasn't one office got treated better than others. We had the exact same furniture and equipment for every single office. It was to save money and be fair, but a person with a disability um, possibly couldn't use that furniture. It wasn't appropriate for them. Couldn't get their wheelchair past the end of the desk from the door or something like that. So, sometimes a policy has got the best intentions, but it can have an adverse effect on an individual or a small group. Um, the other kind of discrimination, which is the batter discrimination, is because no discrimination is good. The batter discrimination is systemic discrimination. So very often, if you're watching the news and there's an allegation that particularly the RCMP or a fire department or a company has been participating in systemic discrimination, this usually becomes newsworthy because it happens because the business or the organization has a practice or a policy or a set of um, traditions um, that discriminate against not just um, one person accidentally, but it systematically discriminates against a large number or regular group of people. And we ought to reasonably anticipate that kind of behavior is going to have this kind of result. And so we very often hear about systemic discrimination more often in the news because it's the batter discrimination. So if you've got a normal way of doing things in the workplace and it has this negative impact on a group of people, then we refer to as systemic. So some examples of systemic discrimination might be doing criminal background checks on everybody. When, for example, I gave you the example of the landscaper sod layer who doesn't go into anybody's house, doesn't go in and doesn't have access to money or vulnerable people or anything, just taking sod off the truck. That then doing background checks on a person where it's not a bona fide occupation requirement could be considered discrimination. Recruitment practices such as favoring or being limited to word of mouth. So these referrals of friends, if that's the only way companies recruit, then you're not making the job available to often to people who are not like the ones that you already have. So if you've got a particular religious group or a particular age group or a particular gender, it's very likely that those people in their personal lives have family members and friends that fall into the same categories and would be referring just that group of people, which unwittingly would be basically saying, we don't ever even entertain people from other areas or groups or races or ages or genders, just because they're coming only by referral. Having a process where we steer people by, say, for example, gender, all the women go to the nursing jobs, all the men go to the truck driver jobs, that would be considered systemic discrimination. So segregating occupations and industries and jobs, this is something I think that people notice these trends that have happened for whatever reason in the past, and they perpetuate those trends intentionally going forward in the future. Job ads that use language, young, energetic, recent grad, men or women only, these are all forms of systemic discrimination. Allowing our customers to choose who our representatives are going to be, who our customer service representatives are going to be, or who are, that sometimes I'd say, well, that might be good for business because it makes my customer happy. But it's not a fair and open and transparent and honest process that gives equal rights of opportunity to every group. There's big data. We talk a lot about social media and algorithms. Oh, my algorithms got me doing this, and my algorithms got me doing that. For some reason, my algorithm, because my sister owns a horse farm, I've got all kinds of trimming of horses' hooves showing up in my algorithm. So these big data algorithms can start to drive people and push them in a particular direction that doesn't make things fair and open and transparent with equality of opportunity to people. Sometimes personality tests, psychometric tests, they're not intended to be, but they can also be systemically discriminatory. Mandatory religious practices by employees who do not qualify as a religious organization. So, you could possibly have a family of a particular religion that owns a business, and they only hire people of the same religion. So you can say, hey, this is a Catholic church, and we need to hire a nun for this nun job, and so therefore you must be Catholic and you must be a nun. That would be a bona fide occupational requirement for that job. But we can't, in a non-religious organization, use religious preferences in our hiring practices. Things like English only rules, these are all systemic discrimination. So age-based limits, mandatory retirement ages, those things are all being overturned by governments. Waivers that may prevent an employee from filling out complaints. No fault attendance policies. So to say to a person, 3 strikes and you're out. You missed 3 days and you're fired and you're no longer required here. If you show up a minute late, we lock the door. Way back in my beginning of the days in this industry, there was a company located in First Canadian Place that had about 200 recruiters. And if you were not in the door by 8:45 in the morning, the door was locked. And the recruiters and consultants were not allowed into the office after 8:45. They had to go to a phone and they had to pitch to their boss why they should be allowed to continue to have their job. And so, you know, under human rights legislation, if your kid is sick and you got to deal with that, and as a result of it, you're 10 minutes late for work, that's family status. You can't discriminate against a person based upon family status. And so this so these waivers of no fault attendance policies, they're out the door. Light duty policies for only work related injuries. So if a person has a disability or has been injured elsewhere, that is considered a disability if they're injured. Like seriously, if you're injured playing hockey on the weekend and you can still walk and go to work, but you refuse to give the person the opportunity some form of modified work, it's not an issue with respect to workers' compensation, but the courts are going to take a look at that one and say, well, what do you mean? Isn't there anything that that person could have done with any value? It may be true. Maybe they couldn't have done anything of any value, but just blanketly saying, injured people who didn't get injured at work, don't come to work, that would be considered systemic discrimination. Pre-employment medical inquiries. Hey, look at this is in the courts all the time. There's certainly certain kinds of jobs like operating dangerous, heavy equipment. You need to prove that you do not have a drug and alcohol abuse issue, or you have to prove that you've got certain vision standards. So pre-employment medical inquiries can have a bona fide occupational requirement, but it doesn't necessarily mean that all jobs have health issues as a bona fide occupational requirement. So when we compare the two, we say adverse discrimination is probably a good policy that may unwittingly or unintentionally have an effect on people or a person of certain groups of people. However, it is a good policy that may require the organization to make an effort to reasonably accommodate that person. In other words, modify the policy for that circumstance. So we accommodate adverse discrimination, and at the same time, we consider, is there a better way to write this policy or have this policy so that we don't have other people and some sort of reasonably predictable way to come about with the same request for accommodation. Whereas systemic discrimination is not a good policy because it systematically or regularly influences or causes a discriminatory result. So when we see that something is a systematic discrimination or just discriminatory policy, we change the policy. So I've used the term accommodation and reasonable accommodation a few times already in my examples to you. So and very often the word reasonable goes with accommodation because you can unreasonably accommodate a person. That's not required. In other words, you can say, we will spend $1 million to get this person a special chair for this 6-month job. That's unreasonable. Spend $1 million to get a special chair for a person so that they're comfortable for the next 6 months. But we could say, hey, that person can start at 9 o'clock, or that person doesn't have to work on the religious holiday. We can change their schedule. So we can reasonably accommodate people, which is an adjustment made to a system to accommodate it, to make it fair for the individual based on a proven need. And that proven need is one of the 11 grounds. So accommodation can be religious, can be because of religious or academic or employment related things. So, we might say, for example, we need to we might say we're going to change our policy because we're always getting referrals and only have been taking referrals. But let's put an ad in the Aboriginal community newspaper. So now we've reasonably accommodated a group of people who don't even work for us yet to give them the opportunity. Or we might advertise in a Chinese language newspaper. Or we might have an apprentice program that is directed towards people with disabilities and older workers, that our apprentice program is not only designed for recent graduates in their first year of employment with us. We might say, hey, we're going to look at the whole world, and anybody who seems to have the qualifications to come here, we'll bring them into our apprentice program if they're the best. They don't necessarily have to just be young or recent graduates. Installing software or features on software, or special keyboards or equipment or visual assistants, or text to voice software, things that are easy to use and easily implemented, would be a reasonable accommodation for a person with this disability. And of course, giving somebody the opportunity to work next Sunday and Monday rather than on their Sabbath or a special religious holiday on Friday would be probably a reasonable accommodation. And we're going to talk a little bit about an example of where the courts got involved as to whether or not it was reasonable to accommodate a person based upon the case that I'm going to show you for religious holidays. Another term that you hear is bona fide occupational requirement. Some people don't say bona fide, some people say bona fide. Some people say bona fide, bona fide. It's a Latin phrase. I'm not exactly sure how it's said, but it's said differently by different people. So if you've got a bona fide occupational requirement, in Canada, we call it a BFOR. In the US, you'll hear a bona fide occupational qualification. They're pretty much exactly the same things. And this is a quality or an attribute that an employee must have in order to do the job properly. So it's a quality or an attribute that employers are allowed to consider when making decisions on the hiring and retention of employees. So in other words, you might say, we might say, we've got a customer service representative who gives tours of this historical jail. And in order to get to a certain part of the jail, there are 3-foot stone walls that are protected under the Heritage Act. Those walls cannot be moved or destroyed. But in order to stop prisoners 200 years ago from escaping, they had to go through a maze, and they would have had to squeeze through this skinny little section between these huge walls. And then there's a person who's applying for the job to give tours, but they are obese, and there's just no way they're ever going to fit through this skinny little section in order to give tours of the jail. So the bona fide occupational requirement must be able to fit through point A to enter the building in order to give tours. I'm sure somebody would find some reason why that was unreasonable and that they should be allowed to work outside or something. I don't know, but the general principle is, if it's really unreasonable to accommodate people, then for particular things, like the nun for the job in the Catholic Church, that means we're allowed to use religion in our qualifications for this job. So therefore it's bona fide, which means it's legit, it's allowed, it's well established and permitted. So a bona fide occupational requirement is a quality that, when considered in the context, would normally constitute some discrimination. Must be Catholic, must be thin, in those two examples I gave. That in this particular case it's not a violation of human rights, because it would be absolutely unreasonable to expect a person who is not a Catholic nun to do the Catholic nun's job. So religion can be used in that particular case. So here's one of the cases that I talked about before, and I'm going to read it to you because this is an old case. This is one. The reason why we have these old cases like this one from 1983 is because very often when we try to make the case, we go back and say, here's the first one. This is the one that kind of set the groundwork or created the case precedents for the hundreds or 2 or 20 that followed after that, or the ones that ended up being codified into statute. So that's why some of the examples we give on cases are old, because they're the ones that paved the way. So Mr. Christie was employed at the Dairy Pool. It was actually called the Dairy Pool, and became a prospective member of the Worldwide Church of God in 1983. The church recognizes Saturday as its Sabbath and 10 other holy days throughout the year. Members of the church are expected not to work on these 10 holy days. And Mr. Christie asked his employer for permission to take up leave on Tuesday, March the 29th, and Monday, April the 4th in 1983, because both of these days were holy days in his church. Now, he was granted leave for the Tuesday, but denied leave for the Monday. Did I get that right? Yeah. He granted leave for the Tuesday, but denied leave for the Monday. And the reason for this was because, think about it, it's 1983. We're dealing with pasteurized and unpasteurized milk. The farmers milk their cows and put them into containers, and they deliver them to the dairy, who then puts them through a pasteurization process and gets them into bags or bottles and tries to get them out, and has to keep them cooled and stored properly and go through the pasteurization process. And so, but they're not open on the weekends. So Mondays are really important days because all the local farmers show up with their unpasteurized, uncooled weekend product of milk. If it doesn't get processed on Monday, by Tuesday, it could have gone bad. So he was given Tuesday off. In other words, let's get all this milk out of the way on Monday, and we can accommodate you on Tuesday. We'll get people to cover you. But he was denied for Mondays. The milk arrived on the weekends, blah, blah, blah. There we go. Mr. Christie did not come in to work on Monday without permission. They said, you can't have it off. But he said, well, religious holiday, I'm not coming. And so they terminated his employment for willful misconduct and willful disregard of their instructions. So the Board of Inquiry ruled that Christie was discriminated against because his religious faith had not been accommodated. However, this decision went to the Alberta Court of Queen's Bench on appeal. So what goes on? Well, the Board of Inquiry originally found that the employer made no significant effort to accommodate the request. And therefore, this bona fide occupational requirement argument didn't fly. The bona fide occupational requirement principle question raised in this appeal was whether or not it was the attendance rule imposed by the employer is a bona fide occupational requirement. If it's a bona fide occupational requirement or qualification, could the charge of religious discrimination have been defended by providing that the employer accommodate the employee up to the point of undue hardship? So here we've got a situation where they said, hey, you didn't adhere to our orders or our instructions, you're fired. He went to court and they said, well, you fired him because he took off a religious holiday, and that's no good. You're wrong. And then they appealed that, and they used the argument that it was a bona fide occupational requirement that you showed up on Mondays because so much milk could go bad if you didn't have enough people working there and have a full workforce, and they didn't have other people to cover for them, and it was overturned. So later on, other cases happened over the years, and they used the same logic for this, except for, with technology and modern advertising and temporary help companies and all kinds of things that have happened. It's not likely that, and the technology around how we handle milk and how farmers handle milk now, it's not likely that that case would ever make its way on appeal. And it would today, the first decision would likely hold its ground, but it did at the time establish that, yeah, bona fide occupational requirement gave a employer reasonable grounds to use a discriminatory criteria in their decision making. So in another case, case number 2, again, way back at the beginning, 1985, the Supreme Court of Canada decided that the requirement of wearing a hard hat is not, or was not in this particular case, a bona fide occupational requirement and amounted to discrimination on the basis of religion, which entailed a Sikh worker to continue his employment without having to wear the hard hat. So the employer, the railway, said, no, you're fired. If you don't wear your hard hat, you're fired. He didn't want to wear his hard hat. There was this constructive dismissal, like, I can't take my headgear off, and you're going to make me do this, so I guess you're firing me. So then it all went to court, and the courts looked at this one, and this is what happened. They determined that there was no shortage of he was a maintenance electrician, and it was a big facility, lots of electricians doing lots of different kinds of jobs there. There was no shortage of maintenance electricians. Unlike the case of the dairy where they said we need everybody hands on, they went, we got lots of extra electricians around. Mr. Binder was not a unique or specialized employee. We got lots of other electricians around. The employer's safety policy would not be jeopardized by Mr. Binder having an exemption. In other words, they couldn't say, whoa, this just opens the floodgates. We allow one, we got to allow them all. They said, no, that doesn't fly with us. If there's a particular reason, time, and a place where Mr. Binder can take his hat off, he should be allowed to take his hat off. Mr. Binder was willing to relocate to a post where a safety helmet was not necessary because it didn't pose a risk to him bonking his head, though he was not willing to assume the duties of a job other than a maintenance electrician. So in other words, they couldn't say, okay, Mr. Binder, you can have this job, but you got to clean the toilets or you have to go in the filing room. He'd say, no, I still want to be an electrician, but boy, there's a lot of jobs around here for electricians where there aren't things that might whack me in the head, and it's pretty darn safe to work there as an electrician. And so they determined that that was okay. He was able to perform it effectively without putting himself at risk. Mr. Binder's fellow employees nor the public would be at risk of being hurt because he wasn't wearing a helmet. I mean, I don't know. I mean, that one's interesting. Let's say, for example, you had to wear safety glasses, and if you got dust in your eyes, you could crash the train into people because you had to close your eyes and squint. So we say, okay, so if we don't wear safety glasses, we don't only put the driver at risk, we put everybody else at risk. Well, that certainly wasn't the case with Mr. Binder and his helmet. When he took his helmet off, nobody else was at risk whatsoever. And the risk of injury to Mr. Binder, if he did not wear a safety helmet, was extremely negligible. So in this particular case, they were unable to establish that there was a bona fide occupational requirement. And so he was allowed for religious reasons to change his uniform and not wear a helmet at work. So we've got 2 different cases, one at the dairy, where they were able to establish that it was a bona fide occupational requirement because all the milk would go bad and the public would get sick from sour milk and so on. And over at the railway around the same time, they were able to establish that it was a bona fide occupational requirement and that it was not a bona fide occupational requirement and that he could get by without wearing his helmet. Same set of not same set of same set of criteria used in order to make that decision. So, which of the following is not a discriminatory practice? Let's go back. There's no shortage of maintenance electricians. Sorry, my apologies. Which of the following is not a discriminatory practice? Denying someone goods, services, facilities, or accommodation based upon prohibited grounds. Well, that's discriminatory. Denying an employment opportunity based upon a bona fide occupational requirement. Not discriminatory because there was a bona fide occupational requirement, a legal ability for a company or an employer to use some area that would typically be considered prohibited grounds as a condition of employment. Paying men and women differently when they're doing work of the same value. That would be discriminatory. We went through that one yesterday in the pay equity legislation. Retaliating against a person who has filed a complaint with the commission or against someone who has filed a complaint with them. We talked about that yesterday. What is that called? That's called a reprisal. So reprising against the person who made a complaint, whether or not their complaint was in the end won or lost, they still have the right to question it without being penalized for questioning it. And of course, harassing someone, we're going to talk a little bit about harassment because of the special considerations that should be given with respect to harassment. So here's an interesting one of case number 3, just to try to drive the point home. In the Western School District, in a unanimous decision, the Supreme Court of Canada restored the decision of the BC Council of Human Rights, which found that Mr. Smith was in fact discriminated against by both his employer and his union because of his religious beliefs. So this one went all the way to the Supreme Court. It went to the Court of Queen's Bench, I think it was Alberta, and then Supreme Court. So Mr. Smith was a school custodian. He was a Seventh-day Adventist. His religious beliefs prevented him from working from sundown on Friday until sundown on Saturday. The work schedule, which required him to work on a Friday shift from time to time, 3 p.m. to 11 p.m., was set out in the collective agreement between the school board and the union. Now, in case you don't know school boards, so typically what happens is you've got these unionized custodians, and you've got a school, and the school's got a gymnasium, and the gymnasium is often permitted or licensed or rented out to various community groups, the volleyball group, the club, whatever it might be, and they often have rules that say people cannot be in the school unless a custodian is present at the time when people are in the school. So this particular individual occasionally had to work a Friday shift from 3 p.m. to 11 p.m. The local accommodating Mr. Smith's religious beliefs would have required allowing him to work hours different from those specified, and the respondent school board and union could not agree on a means on how to accommodate Mr. Smith, and as a result, he was dismissed from his job. His requests were too much of a problem, so let's just replace him with somebody else. The BC Council of Human Rights found that though it was a bona fide occupational requirement that a custodian be present in the schools, it was not a bona fide occupational requirement. And then, of course, it went to appeal, and they found that it was a bona fide, was not a bona fide occupational requirement, that there were enough custodians around that he could be replaced. So in that particular case, they went through all the same things. They said, hey, are there a lot of custodians? Yeah, there are. There's a lot of custodians in lots of other schools. Lots of them that would probably love to have the extra hours to work over at his school on Friday night. So they all do the same jobs. There's no shortage of custodians. Yes, it might put the public at risk if you didn't have a custodian, but you could reasonably accommodate him by getting a custodian from another school to come over and work that shift, so it didn't put the public at risk. So they go through the exact same decision process. And without getting into this, there's typically what happens is you've got your court or tribunal, depending upon how the province and how the complaint is processed, go to a human rights tribunal. Then if it's found at the tribunal to have a decision that one of the parties disagree with, they can appeal it, and it can go to a higher court within the tribunal or to a regular court. And if that is disagreed with, you can make application to go to a higher court like a Supreme Court. Now, just so that you know, in order to typically elevate something to a higher level to get to a Supreme Court, there has to be a question of the application of law, not a question of facts. So you can't go to the Supreme Court and say, we're introducing new facts. You would have to go back to the lower court and say, I've got some legal reason to deal with this again because we found some DNA or something like that. There has to be new facts, because the lower court will determine what the facts are, and then the raising things to a higher court is saying, hey, did that court take those facts and apply the law correctly? So then they're going to ask questions like, okay, here's the facts. Is it a bona fide occupational requirement? Is it not a bona fide occupational requirement? Was it reasonable to accommodate that person? Was it unreasonable? And so the application of the law for the reasonableness of it, or the degree of which it applied to the law, can be appealed. This case probably should be replaced with some newer cases. Boy, there's been a lot of issues since this case was decided with respect to Hockey Canada, around things like discrimination, sexual harassment, gender, equality. Hockey Canada has been at the forefront of a lot of controversy over a lot of years. But in this particular case, Hockey Canada agreed to make changes to its to protect its young players in Ontario from discrimination or harassment based upon players' transgender status. So, I'm not exactly sure what their policy was that had to be overturned, but clearly, transgender athlete or athletes took issue with things like dressing rooms and the way that they were identified, and around the behavior of the coaches and the facilities managers and so on. And so their resolution was that they would provide training, Hockey Canada would provide training to all of its Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment. And they would amend its on co-ed dressing room policy, which would be publicly posted on websites and around the buildings. And that these policies would include that a player has a right to use a dressing room that corresponds with the player's self-identified gender. A player shall be addressed by the player's preferred name and by their preferred pronouns corresponding to the player's self-identified gender. And a player is entitled to the privacy and confidentiality with respect to a player's trans status. And information about the amended policies would be accessible to staff, volunteers, and parents all across Ontario in a very open and transparent way. Now, I want to point out that these court decisions have been made in Ontario, and they continue to evolve and remain consistent. Do not be confused by what Donald Trump is doing in the United States, where he's attacked DEI and gender in sports. Those are political decisions that are unique to the current elected government and politicians in the United States. They are not relevant to the discussion in Canada. And in fact, because of the use of language that is very similar, it's possible we'll have some detrimental effects in Canada because of people's misunderstanding of how the terminology is used. So let's just kind of do a little review of this stuff, and we've got 20 more minutes before our first break. Testing our knowledge. A policy provides benefit to some married couples, but not to others. This would be a case of family status discrimination. A person is identified a job because of a person is denied, a job because of a previous conviction for which a pardon has been granted or a record of suspension has passed. And so that would be discrimination based upon pardons and convictions. Number 3, an employee has a reaction to dust and chemicals. This would be considered a disability. Number 4, a female employee with an excellent performance record announced that she's pregnant, and then immediately her employer begins to identify performance issues that lead to her dismissal. This would be an issue of family status and religion. So number 6, an employer assigns employees to weekend shifts without recognizing that the employees observes the Sabbath. So that's like one of the cases we had. That would be religious discrimination. And number 6, an employer's physical fitness requirements are based upon the capabilities of an average 25-year-old. In other words, you have to run and have a certain amount of stamina and hold your breath and do whatever and these requirements are not closely related to the actual performance of the job. And so that would be considered age discrimination. So the next question is, and we're going to get this done before our little break, is harassment. Is harassment a form of discrimination? And the answer to that is yes. Most provinces have now written very specific legislation around harassment. And it's found its way either into their Employment Standards Act or into their human rights policies. And in some cases, like for example, in Ontario, into their workplace health and safety, regulations and policies. So providing a safe workplace has found its way into safety legislation and human rights legislation and employment legislation, and different provinces have addressed it in different ways, but they have all identified harassment around issues of prohibited grounds to be discriminatory. So harassment is a form of discrimination and involves an unwanted physical or verbal behavior that offends or humiliates a person. Generally, harassment is a behavior that persists over time. It is a series of incidences, but can be one severe incident if it is super severe, which has a lasting impact. So it has the same impact as if it were multiple and recurring and persistent incidences on the individual. So a serious one-time incident can sometimes be considered harassment. So if 2 people got into a fight, that would be bad, and it would be a violation of a policy, but wouldn't necessarily fall under the category of harassment unless they said, hey, this was a very severe incident where one person was severely bullying, harassing the other. But if a person is constantly poking a person, then for sure that would be considered harassment. Harassment occurs when someone makes unwelcome remarks or jokes about race, religion, sex, age, disability, or any of the 11 prohibited grounds. If in doing so, they threaten or intimidate the person, and if they make unwelcome physical contact, such as touching, patting, pinching, punching, can also be considered an assault, but it definitely can be considered harassment. So, where can harassment occur? By the way, harassment is one of those unique things where if people work together, but the harassment occurs outside of the workplace. I'll give you an example. I've got a customer, it's an Ontario government, Ontario Heritage Foundation type of customer, like they operate agricultural facilities and museums and so on. And some people work together, and they very often people go to in the summertime, go to an outdoor cafe after work. And it's a common place where people from work go. It's kind of like the Starbucks right beside the office kind of thing or something like that, but it's not a Starbucks. And there were two particular gentlemen that persistently harassed this one other employee, a transgender employee. They never harassed him at work, but every time at that cafe, they harassed him. And as a result of that, there was a complaint made at work, and it was found that this was workplace harassment. So harassment is one of those things that doesn't necessarily have to happen within the physical confines of the facility. A complaint of harassment must be filed within 12 months of the last alleged event. So it could happen for months or years. But once the last time it happened, the complaint has to be made within 12 months. And the statute of limitations with respect to complaints is generally intended to say, if it's real and it's real harassing, then thinking about it after the fact may not be accurate. That if you didn't feel harassed at the time, then maybe it didn't rise to the level of harassment. And then, of course, there's all these issues about like how difficult is it to prove, and are there people around, and are there legitimate witnesses, and all kinds of things. So, legislation is constantly trying to put these statutes of limitations or time limits on when complaints must be made with respect to the occurrence of the incidences that are arising to cause the complaint. And then from time to time, we get real, and governments look back at it and say, hey, when a person is traumatized by something, they're maybe not in a condition, or they feel so harassed that they feel threatened to complain. So they don't complain. They didn't feel safe to complain until 2 or 3 or 5 years later. So there's this conundrum that exists in this particular case with respect to in the province of Ontario. There's a 12-month statute of limitations from the last date. Now, it doesn't mean that it only can include the last date. If it happened for 2 years and the last date was 9 months ago, then everything counts in the complaint. It's just that there has to be less than 12 months from the last date of the last incident. But once you make the complaint, everything that happened for years and years and forever prior to that can be included in the complaint. Identify and select some of the answers below that do not consider harassment. So discrediting the person by spreading malicious gossip or rumors, ridiculing him, humiliating him or her, calling into question his or her convictions. Well, that would be harassment. A single or isolated incident, such as an inappropriate remark or having an abrupt manner, that would not rise to the level of harassment. So we see this happens all the time. I don't like my boss. My boss is really gruff and, direct, and he or she hurts my feelings. Well, that doesn't necessarily rise to the level of legal harassment. Unwanted sexual advances, which may or not be accompanied by threats or explicit or implicit promises, that would be considered harassment. Making rude or degrading or offensive remarks. If they're made once or twice, they might be a breach of policy. Um, if they're made all the time and they have an intent of doing something, then they would rise to the level of harassment. So I'm not sure there's enough in number D to say that making rude or offensive remarks, making rude or offensive remarks are rude and offensive. Making rude and offensive remarks all the time on a repeated basis to the same person or group of people could be considered harassment. Friendly gestures amongst coworkers, such as a pat on the back, that would not be considered harassment. Even a pat on the butt would not be considered harassment. It might be inappropriate, but would and should be dealt with, but would not, and should be dealt with for other reasons, but wouldn't be dealt with in the form of harassment. Isolating a person by no longer talking to him or her, denying or ignoring his or her presence, distracting her from others, that would be considered harassment. And so B, isolate a single isolated incident is not harassment, and a friendly gesture among coworkers would not be harassment. The others could be considered harassment. Okay, last thing, 22. The last thing before we take a break. This may be the last thing before we take a break. Quid pro quo. So this is another Latin term that you'll often hear in a legal context. Now, by the way, quid pro quo in itself doesn't mean something bad happened. It means this for that. You give me something and I'll give you something in return. So two neighbors could participate in quid pro quo. You shovel my driveway, I cut your grass. That could be considered a quid pro quo relationship. But it's often used in the context when we're talking about human rights and employment. It's usually used in a negative context, about inappropriate behavior. So it can occur in a workplace where a manager or another authority figure offers or merely hints that he or she will give the employees something like a raise or a promotion in return for their employees' sexual satisfaction. So that would be considered sexual harassment, and they would talk about this quid pro quo. You do this, I'll do that. Changing work standards after an employee consistently refuses or repeats a request for a date. So, hey, you want to go for coffee? You want to go for dinner? You want to come with me to the show? How'd you like to come to my party? No, thank you. No, thank you. No, thank you. Then next thing you know, the person's got an office in the basement. That would be considered an inappropriate quid pro quo. You got this bad treatment for having the right to refuse those requests. Disciplining or firing a subordinate who ends a romance. So there's lots of company policies that are against co-workers entering into personal relationships, but that's not against the law. What is against the law is making that quid pro quo. What is against the law is retaliating against a person because it ended. And so companies have these policies in place because they become really messy, and they often appear to be unfair, and they often result in less than objective behavior. And so firing a subordinate who ends a romance or sending them into the basement would be considered inappropriate quid pro quo. The job opportunity will also may be the subject of this kind of harassment if the hiring decision was based upon the acceptance or rejectance of sexual advances. So we can see from the advances on the screen that very often the term quid pro quo is used in terms of sexual harassment, inappropriate touching or offers. They're generally not around sharing sandwiches in your lunch bag. The summary of the Human Rights Act, the act in itself states it's the principle that all individuals in Canada should be and have an equal opportunity to make for themselves the lives that they are able and wish to have. So it doesn't say that we have to have equal outcomes. It should they have equal opportunity to make for themselves the lives that they wish to have, and to have their needs accommodated if there is some form of barrier based upon one of the 11 prohibited grounds of discrimination. The act is meant to promote this equality by prohibiting discriminatory practices based upon specific attributes such as race, sex, creed, color, place of origin, sex, sexual orientation, religion, the 11 prohibited grounds. And so again, the Human Rights Act is not intended to affect outcomes. It is intended to affect barriers to fair and equal opportunity to outcomes. Okay, so we're going to take a break. It's 2:27. We're going to come back at 2:37, a 10-minute break, and we're going to jump into the topics of the controversial topics of diversity, equity, and employment equity and inclusion. And then we've got an hour and a half through to the end of our session. Again, please remain on the line. Just stay muted. You can turn your cameras off if you get your cameras on. I'm going to do that. Try not to leave and come back, because that requires me to notice that you're left and come back, and I'm not good at noticing things. So I'll see you back here at now 2:38. See you in 10 minutes. Chance to just get themselves settled in before we start again. Before we move on to the next section, I just want to do two things. One is I want to review one issue about the process with a human rights complaint, and then we're going to ask if people have questions. Personally, my companies have never had a human rights complaint, but as a consultant, I've had several companies, customers of mine, who have, and I just want to say this much, that it is emotional, very, almost always, I think always, in every circumstance that I'm familiar with, the companies that have had complaints made against them feel as though they were not discriminatory and did not discriminate, and that they have a set of policies and practices that are fully compliant. And and yet they still had a person or used the Human Rights Commission to file a complaint. And so there can be, and very often is, a discrepancy between what a person means and wants and thinks they're being perceived as, and how the other party feels as though they're being treated. And there's sometimes an incongruence there, and they don't align well. And so one of the things that I always suggest to people is that they have these open discussions about how do you feel and how happy are you, and they have satisfaction surveys, and they have committees, employee committees, and people participating in those committees, and they have open door policies and opportunities for people to express their concerns, so that they don't get caught, so an employer doesn't get caught off guard. Secondly, the commission often seeks a resolution and not a penalty. And very often those resolutions can feel more punitive than a penalty. I mean, a penalty might be, you have to pay this person an X number of dollars, and a resolution might be like the example we gave with Hockey Canada, where they had to implement a whole bunch of training policies and practices and change all kinds of things that might have cost them millions of dollars to to roll out all of the training and all the changes in physical facilities and rooms and building rooms, for their players. And so sometimes the resolution can seem quite punitive when in fact the resolution is not intended to be punitive, it's intended to be corrective. And so it's really, really important that as employers that we're aware of how our policies and practices make people feel, because even if we think we're doing it right, and even what matters most is how do other people feel. And even if we can avoid a penalty and found to be at fault, the settlement might be a corrective action, which can be quite overwhelming, had it when it's done under mandate rather than naturally through a normal iterative process. And then finally, um, as employers, we need to hire specialists and lawyers and people to help us through those unintended and unwanted processes and complaints, whereas the services available to the employee are often free. As a matter of fact, I had one case with a client a year ago where it seemed pretty obvious to me that when the person got fired, they got fired for good reasons. And then a year later, 9 months later, they made a complaint to the Human Rights Commission. And they made it through the Human Rights Commission because I'm pretty sure the Employment Standards Branch said no, and an employment lawyer said no, and eventually somebody said that your only hope here is to prove that they discriminated against you. And the first complaint came through was really vague and not effective. It didn't even make allegations that fell within the code. But they had 3 modifications over a 1 year period that came as a result of consultations with staff from the Human Rights Commission that were assigned to the individual to help them with their claim. And so individuals at the Human Rights Commission, in order to make things fair to people who might be marginalized, it became quite obvious that they were taking words right out of the act and putting them into the allegation. Now, in that particular case, the employer, I thought, was a good employer. They understood what was going on. They made a settlement, but there should it should have never happened in the first place. And so I caution people that sometimes think we're doing the right thing. We want to do the right thing, but it's important to also be very aware of what others think and believe we're doing. So it's not only important to be right, it's also important to be perceived that you're doing it right. And sometimes they're the same thing, and sometimes they're not always the same thing. Okay, before we move on, I see everybody's muted. Does anyone have any questions about what we talked about for the first half of today? Okay, let's rock and roll. Okay, so this one is probably not that relevant to some of the people on the line, unless, of course, you're doing providing people to the federal government or to a federal crown corporation or a federal entity, because the Employment Equity Act, there is no Employment Equity Act in any of the provinces that I'm familiar with. But there is a federal Employment Equity Act, and it's very specific. It deals with women, people with disabilities, Aboriginal people, and people with visible people who fall into the categories of visible minorities. And the whole intent of this Federal Employment Equities Act is for the federal government and for federally regulated organizations like banks and railways and airlines to make an effort to develop a set of policies and practices that will encourage them to hire a workforce that reflects the demographics of the community of which they are recruiting from. So if they're in northern Saskatchewan, for example, one of my clients there, higher percentage of Aboriginal people in their community than, say, for example, what we might find in where I work and live here in Mississauga, Ontario. And as a result, they really needed to take a look at some of their practices so that their workforce over time would more closely reflect the demographics of the community that they worked in. It doesn't mean that you have to have a DEI policy and give, you know, extreme prejudice towards a particular group of people, hire a person who's unqualified. There's no quotas or goals and objectives. The objective is to look at a set of policies and practices that would create an equitable opportunity for everyone from the community to apply for jobs, so that if you hired the best people, most qualified people for the job, that over time it might more accurately reflect the demographics of your community with respect to women, people with disabilities, visible minorities, and Aboriginal people. And sometimes I click and it does not go forward. It does not have to deal with quotas. So the purpose is to achieve this equality in a workplace so that no person shall be denied employment opportunities or benefits for reasons that are unrelated to their ability, and to correct any of the conditions of disadvantage in employment that might be experienced by women or Aboriginal people, persons with disabilities, or visible minorities, that may have had the effect to not create equity or equality of opportunity for employment. So employment equity means more than just treating persons in the same way, but it also requires sometimes some special measures that will help us to accommodate some of the differences that have accumulated over the past. So when you've got a provincially regulated business like a staffing company, this doesn't apply to us because it's a federal legislation. We would have to look to see, is there provincial legislation that applies to us, and there typically isn't. Typically, the provincial governments say, hey, we got lots of human rights legislation and pay equity legislation and AODA legislation and things, and we're getting the outcomes that we want or that we're setting out for without having something special in place. But the federal government says that if you're going to be providing services to the federal government as a contractor to the federal government, and you have more than 100 people employed, and you've been awarded a federal contract for goods or services of $1 million or more, then thou shalt comply also. That you need to do the same administrative types of things that are required of the federal government in order to be a supplier to us. Now, this is particularly relevant to staffing companies because really, like if the federal government gave somebody a $10 million staffing contract to supply people and they had a $100 million budget, they don't want to have this $10 million piece of employees over here not complying to the same standards and practices that they have for the other $90 million worth of people sitting right beside them. And so they pull in the large suppliers with a contract of more than $1 million and more than 100 people. Now, on the face of it, you could say, well, this applies to pretty much every staffing company all the time who's got federal government contracts. But there's tends to be some practices saying, okay, this is based upon an establishment. So, Ottawa doesn't need to be mixed together with Toronto and doesn't need to be mixed together with Calgary, where somebody might have three separate contracts. Let's look at each individual contract. The federal government contracts are usually under RMSOs, regional master standing offers. And so they're going to look at the $1 million contract in that one contract, not the sum of all the contracts. And so a lot of the staffing companies don't have to comply with this. But if you did need to comply, there is a section that they have on their website for for provincial contractors. And even if you didn't apply to it, it's important to kind of understand what employment equity. You can't see me. I'm making little quotes with my fingers. Employment equity, because the term is often used, particularly in the United States, in a different context. So for employment equity here, what we do is we conduct a workforce analysis. We say, all right, how do we blind, not down to the person, but get percentages in big picture of how many women and men work in our organization, how many are Aboriginal and not Aboriginal, how many are visible minorities and not, and we get percentages, people with disabilities and people without disabilities. And so we get percentages so that we can take a look at what the demographics of these four targeted groups look like in our workforce. And then we take a look at, sorry, that's for the workforce. That's for your community. So you get the numbers for the community. Then you do the same thing for your system, for your employees. And now we compare step number 3, we compare what does our community look like and what does our workforce look like, and there are some big gaps. Is 5% of the community considered to be self-identified people with disabilities, and 0% of our workforce has disabilities? Well, we're not representing our community in a sort of fair and equitable way. It's skewed. So we take number 1, the workforce; number 2, our systems and our people. We compare the two, and then we create a plan that says, what are we going to try to do over the next 2 or 3 or 5 years that is going to try to balance this out so that we provide greater equal opportunity to all of the groups, so that when we start to do our hiring, it starts to look more like the workforce that we're hiring from. And then we have to establish, after we created the plan, we have to put it into place, which usually means things like when somebody gets hired, they fill out a form and they self-identify, and that form gets separated from their employment record. It goes off to the employment equity officer, and it goes into a database or into a place that doesn't have the name associated to it, so that nobody, the supervisor, human resources, can't look at it and say, whoa, wait a minute, you identified as this or that. We can use the information inappropriately or unfairly. And so it's supposed to help create statistics. So we've got this method of collecting the data and method of analyzing the data. And then we've got this process for maybe setting up committees or commitments, or changing where we advertise or how we advertise, or using different language, or implementing equipment or something to deal with our, it could be as simple as having only non-kosher food in an off-site location in an employee cafeteria. So it could be really remote location. Everybody eats basically the company food from the company cafeteria, but some of the food doesn't help people who need gluten-free food because of a illness or disability, because they're celiac or something, or because it's non-kosher because of their religious beliefs. So we say, hey, we need to have a more diversified food in our cafeteria so that a more diversified workforce might want to work here. So these are simple things that people can identify as being barriers that would create some pattern of hiring that don't reflect the workforce analysis. And then every year you do your workforce analysis, you do your employment systems analysis, you write a report on what the new statistics are, what they were, what they are now, some of the things that you've done, and you submit that report to, it's called the LEAP report. It's pretty straightforward. If you didn't, I mean, the only way you could fail this is not do it. You could be identified as a contractor and make a commitment to it and then not do it, not do your analysis, not do your comparison, not have committees that attempt to affect change. So um, you could fail by doing that. But if you don't get the results that you kind of hope for, then you keep trying. Then you just say, okay, our percentages are still different. Our workforce is different from, uh, or the workforce has got different percentages than our employee base. And we tried these things. Let's try some more things. And so you continue to move forward. So employment equity involves all of the following except for one thing, and let's go backwards again. Um, Number B, it does not include government imposed quotas. There is no quota system in Canadian employment equity. Okay, so what are two of the demographic pressures affecting the Canadian workforce today? Well, there's a large number of baby boomers who are approaching retirement age or in retirement age. There's a large number of people in retirement age that don't want to retire. There's a lot of people in retirement age that possess trade skills that young workers don't want to do. And so they don't go through training, or maybe there's a whole bunch of trade skills that industry and trades and unions have not, and schools have not built a system to train those people to do those trades. There is a shortage of young workers, and so Canada, and if we take a look at what's happened with our demographics in Canada, most of our population growth has come from immigration. And Canada has struggled in terms of our natural population growth through having 2.1 babies per family, that we've struggled in terms of actually growing in population. And so as the economy grows and as business grows, we've had to rely upon immigration as part of our ability to provide a proper workforce. But our immigration policies haven't necessarily been tied to workforce demands. They've been tied to all kinds of social programs and reasons, some good, maybe some not so good. It depends upon your politics and your beliefs. But they haven't necessarily been tied to filling the demographics of the types of skills, education, and wants and desires and abilities in order to deal with the changing needs of our workforce. In Ontario, we've got a very special program called the AODA, Accessibility for Ontarians with Disability Act. This legislation was, I don't remember the year. I'm going to say 2010-ish, was implemented in Ontario with a long trajectory. Maybe in one of the next slides it tells us, with a long trajectory for each of its phases to kind of roll in. So the Act speaks of developing and implementing and enforcing accessibility standards in Ontario in order to achieve accessibility for Ontarians with disability with respect to goods and services and facilities and accommodations. So it's businesses, it's transportation, it's buildings, it's hotels, it's new condominium structures and premises. It was intended to deal with a whole bunch of other things. And they set out a whole bunch of milestones that all needed to be implemented. So 2005. So the legislation was passed in 2005, and it had 5 different sort of stages to it. The first stage was a customer service stage where we as Ontario employers were obligated to provide a customer service training to our employees to understand the legislation in itself, to understand disabilities, to respect those disabilities, for us to understand what kind of things we needed to do with respect to information and communication with people with disabilities and communication to the community, what we needed to do to accommodate people in employment. We get down to some of the issues around transportation. And then finally, the reason why it was a 15-year or 20-year plan was because it also got down to elevators and ramps and all kinds of construction, building facilities, accessible washrooms, and so on. And I'm gonna tell you a little story. I mentioned Samantha to you earlier today. Samantha's in a wheelchair. She's been in a wheelchair for 30 years, all of her life, and she cannot transfer on her own from. She's in a manual wheelchair, and she needs an aid because of her disability. She needs an aid. Someone needs to be with her 24 hours a day. She can be alone in a room and play with her computer and watch TV and eat, but she can't cook and she can't transfer and dress. And so she needs to have an aid. There's no way she could get from here to the bus stop on her own, and she would need to have someone accompany her wherever she went. So along comes stage 4 of the transportation part of AODA, and every municipality in the province looked at their busing and transportation system, and they started to introduce these really cool buses. Some of us, they're called kneelers, and so then the bus comes up and then it lowers down and kneels, and a ramp comes out, and people with walkers and wheelchairs and scooters can onto the ramp, and then it lifts them up, and then it kneels back up straight again, and they can move onto the bus, and there's spaces on the bus where they can get locked in, and it's all really cool, and it's really awesome for people with mobility issues. And so Samantha used to also have a caregiver that was with her all day long, and that caregiver would accompany her to programs and stores and swimming in school and so on. And they used Wheel-Trans and Trans Help, it's called in my area, but it's Wheel-Trans. So it's like $7 a ride or something. It's more expensive than taking the regular bus, but it's run basically by the regular bus people in the municipality, and you would phone and book an appointment, and they'd come to your house and they pick you up and they take you to wherever you got to go, as long as it's within the city limits and within their area. And you book an appointment for them to come pick you up and take you home again. And in her case, she had to have an aide with her. Well, the city came along and said, because of AODA, all of our regular buses now can accommodate wheelchairs, so you're no longer eligible for Wheel-Trans. Because we've met the provincial standard, and all of our buses can accommodate people in wheelchairs. Except for I live in a neighborhood it's like 3/4 of a kilometer or a kilometer and a half, I don't know, to the closest bus stop, and there's no sidewalks, and there's ditches, and it snows and ices, and it's a manual wheelchair. And so really, like in February, is she gonna like trudge through the ice and the snow with her hands on the wheels, pushing to get, a kilometer away to sit outside at 20 below zero to get a bus? And so under the AODA rules, them saying all of our new buses can accommodate people with wheelchairs, basically meant she's never going to go out in the wintertime. It's just not going to happen unless we drive her and put her in the wheelchair van. And so she can't go with her aide. So we appealed that, and we talked about it, and they accommodated us. They said a reasonable accommodation would be that you use transportation, the public transportation system, up until November the 1st, and from May the 1st until November the 1st, you take public buses, and between November the 1st and May the 1st in the wintertime, you're eligible for Wheel-Trans. So, this is a perfect example of 2 concepts. One is AODA, phase 4. Everyone was required, particularly municipalities and government, but businesses also to provide. Phase 4 was mostly municipalities and government. Phase 5 is everybody. Phase 1, 2, 3, and 5 are everyone. That they needed to accommodate transportation, so they went to great lengths to accommodate people under AODA legislation. They were required to get these buses that would do it. And then back to our concepts of discrimination and reasonable accommodation, they came up with a way to reasonably accommodate her under the discrimination, human rights legislation, in order to make sure that she still had access to normal public transportation during the winter months. So there's a little story on how AODA and reasonable accommodation kind of work together. So the reason why AODA exists in Ontario and other provinces have similar legislation, that 1 in 7 Ontarians is deemed to have some form of a disability, and that 95% of those people with disabilities, that they're hidden, that is not a visible disability. It could be hearing impairment or cognitive impairment or other impairments that affect an individual. Of course, in the case of Samantha in her wheelchair, it's obvious that she's disabled, but that is not necessarily the case 95% of the time. It's estimated that 1 in 5 Canadians will be 65 or older by this year. 20% of our population, 65 or older, and half of that group will have some form of a disability. More than 500,000 Canadian adults have some form of vision loss that is not corrected by glasses, and more than 1 million live with some form of hearing loss that is not corrected by hearing aids. This is a lot of people with types of disabilities that can be more readily and easily accommodated, particularly with today's technology, without really putting people out, so they can be reasonably accommodated. And then, of course, let's not even go there to any significant degree, because it's impossible to really get into context the significance of mental health illnesses and the effects they have on Canadians directly and indirectly, not only for the individual, but for their families and for their friends and for their employers. And this is everything from Alzheimer's and dementia for the elderly, to cognitive disabilities for young people, and then for people in between with substance abuse and anxiety and all kinds of other illnesses that we just don't see. And we just, and it's inappropriate to ask. And so, by having an AODA policy, it basically says, we're going to create an environment. We're not just going to accommodate an individual because they told us they needed accommodation, but AODA legislation really is designed to create an environment that is provides the opportunity for people with disabilities and mental health issues and hearing impairment and visual impairment and mobility issues to be able to function effectively in the workplace. And I use this analogy all the time because I was president of an association called the Ontario Track 3 Ski Association. We help hundreds and hundreds of children with disabilities to experience the thrill of skiing and snowboarding in the wintertime. So we have special adaptive equipment and hundreds and hundreds, 3 times the number of instructors and volunteers than we have children, because it often takes 2 volunteers to deal with 1 child with a disability. And, we talk about the mountain and the gravity of the mountain providing the opportunity of thrill and excitement and engagement and participation and the feeling of self-worth. And so we've got this issue of a mountain being the vehicle for change and opportunity, yet a curb only this high, not a mountain, can be an absolute barrier to a person in a walker or in a wheelchair. And so we sometimes we don't recognize, I know that when we go places, sometimes we have to walk 400 meters that way. Now I'm strong enough that I can
Onto the
lift the
stream.
wheelchair, but most people can't. And so sometimes you have to go 400 meters that way to just find a way to get off the road and onto the sidewalk, to get into a building, to find a place that's accessible. Because even though the mountain can be the 10,000 feet of a mountain can be the vehicle of opportunity through gravity, 4 inches or 2 inches of a curb can be the barrier to accessibility and opportunity for an individual. So, if we create organizations that have got this kind of accessibility, then we also open up the doors for two things. One is to get a better workforce that the brightest and the most motivated and the most educated and the most skilled people, including people with disabilities, have an opportunity to work inside our organizations. And secondly, we become more, when we hire people with diverse backgrounds, we become more aware of the needs, wants, desires, fills, holes, guilt, things that people need and want as customers of ours. And by having that workforce that represents the community that we work in and the people we serve, we become better service providers and are more likely to be successful. So, what are these disabilities? Physical disabilities, infirmities, malformations, disconfigurations, learning disabilities, mental disorders, injuries. These are all considered to be disabilities. They can be intermittent, they can be permanent, they can be temporary, they can be overcome and removed and go away. And they don't necessarily all have to be permanent. It's a disability. So we under AODA legislation, we're all required to have a policy. If you don't have a policy, then you can download them, you can find them, you can hire consultants to do it. They're available on the AODA website, sample policies, but
No. Oh,
here's an example. Sorry, is anyone question? Here's an example. An organization is committed to providing exceptional service to our customers. Our service will be provided in a manner that respects the dignity and independence of all customers. The provision of services to persons with disabilities will be integrated wherever possible. People with disabilities will be given an opportunity equal to that given to others to obtain, use, or benefit from the services provided by our organization and on behalf of our organization. So there's a simple policy that's quite generic, that needs to be signed by an executive, and you need to have a committee that enforces some of the virtues of that policy. So AODA policies require that there is training, that there is the use of assistive devices, and allows for the use of service animals and support people. There has to be notices to people with disabilities when there is a temporary disruption to, say, for example, the elevator or escalator is broken. Then we need to provide notices to those people. There needs to be a feedback process in the legislation so that if people don't agree with your policy or don't like your policy or don't think your policy exists, that they can give you some feedback about improving your policy. And there needs to be, because it is for people with disabilities, that all of these notices and feedbacks and training all have to be offered in a way and a format that is available to people with visual and hearing and cognitive impairments. Okay, so let's jump on now to the next topic, which is DEI, diversity, equity, and inclusion. And I just kind of want to repeat what I said earlier today, that DEI, in the context of which it's being discussed in America right now, is misleading with respect to how and what we think of DEI in our policies and practices here in Canada. Whereas DEI policies, it seems in the US, I'm not an expert in the US, it seems as though it was perceived as, in some cases, like, for example, access to getting into universities, that it seemed as though it was providing some sort of unfair or unequitable advantage to the more diverse population, and possibly being unfair to people who are not identified as being part of a diverse population. And I don't think it was intended to be that way, but it has become that way. It is the language that the current government is using, and some of the executive orders sort of made it become that way, or at least perceived to be that way. This is not the case in Canada. We haven't added or created new meaning to DEI. It doesn't mean something negative. It doesn't, it's not a political football. It's just what it is. Companies that are diverse and equitable and inclusive are better able to respond to the challenges, to win top talent, to meet the needs of different customers. And with DEI in mind, Canadian employers are considering how to better support their employees more than ever, with a focus on attracting and motivating and retaining a diverse workforce. It's not intended to be quotas. It is not intended to be unfair. It is not intended to provide advantages to certain groups and disadvantages to others. It is intended to provide gender diversity, age diversity, ethnic diversity, physical and neuro diversity to our workforce and to our customers and to the way that we operate our businesses. And it's intended to make us better, not quoted, if I can put it that way. So equity refers to this fair treatment of people, so that the norms, practices, and policies in place ensure identity is not predictive of opportunity. So we don't look at a person and identify them in a way and say, well, that predicts they're going to be successful or that predicts they're going to be unsuccessful. It's to remove those identity predictors. Equity differs from equality in a subtle but important way. While equality assumes that all people should be treated the same, equity takes into consideration a person's unique circumstances and adjusts the treatment accordingly so that they have an opportunity for an end result that is equal. It doesn't mean that we're going to make it equal. It doesn't mean that everybody must be given exactly the same pay or exactly the same things. It means that we're going to create an environment where some people can take this path and some people can take that path, and that each path is designed in a way to provide opportunity in an equal way so that we can have outcomes that are fair at the end without people being discriminated against. Now, inclusion refers to how workforce experiences the workplaces, the workplace, and the degree of which the organization embraces all employees and enables them to make meaningful contributions. So inclusion is having committees. Inclusion is asking people how they feel. Inclusion is listening to people's complaints. Inclusion means that when we come up with a policy and we think we're doing the right thing and we want to do the right thing, that we listen to everybody on how they feel that it is affecting them. Companies that are intent on recruiting a diverse workforce must not only just say, oh, we, hire people from everywhere, but they also have to strive to develop a sufficiently inclusive culture in the organization once they arrive, so that employees feel that their voices will be heard inside the organization. This is critical to organizations if they want to retain their talent and unlock the power of a diverse workforce. Now, I got to tell you that the first time I ever organized, it was an ACSESS meeting. It was like 1989 at a place called Berlin at Yonge and Eglinton. And 200 people from the Toronto chapter came together as we talked. This is 1989 as we talked about the importance of diversity in a workforce, so that when you supplied tellers to a bank, that there was going to be some tellers behind the counter who could speak the language of the customers in front of the counter, so that those customers would remain to be customers. And so that when we brought people into the hospital and we were supplying temps and doing permanent recruiting for people who worked in the hospital, that when people showed up and spoke different languages, or had anxiety and depression, that the people dealing with them understood these things and could explain things in a way to them that they understood, so that they got the health care that they desired and that they needed, and that they understood their options and could make choices. This made for better business. It made for more profitable staffing companies. It made for a more effective and functional society with organizations that really strive for excellence, and that their performance is always rising, not because they only speak one language, or they only talk to certain kinds of people, or they can only accommodate people into a physical facility in a particular way. That we become more successful as we are able to serve the communities and the demographics of the communities that we work in. That includes our customers, our customer base, whether they're corporate customers or walk-in customers. We're better businesses when we're diverse, when our employment group is diverse. So when we talk about DEI, we look at, in Canada, we look at human rights legislation. We look at employment standards legislation. We look at employment equity, that federal contractors legislation. We look at the AODA legislation. We also look at things like the harassment legislation that was put into our workplace health and safety things. And finally, for the last few minutes, we're going to talk about privacy. Privacy legislation was introduced by the federal government that had a lot to do with the Charter of Rights and Freedoms, because not only do people have the rights to have access to information and openness, but they also have the right to their own privacy. And so privacy really talks about the PIPEDA. You hear the term PIPEDA, P-I-P-E-D-A. PIPEDA means the Personal Information Protection and Electronic Documents Act. Now, this federal legislation was intended, it protects the personal information in the hands of the private sector and organizations and companies, with guidelines for them on how they can collect it, how they can use the information, who they can disclose that information to, and how it can be used in their commercial activities. So some of the things, like, for example, might be collecting credit card information when you're selling things and people set up, let's say, the airline, you set up an account and you save your credit card in there, so that the next time you go to buy an airline ticket, your credit card information is already in there. Well, under PIPEDA legislation, they've got an obligation to protect that personal information so that it cannot be used for any intent or purpose, or any purpose for which it was not intended for. So they can't take all of that info and sell it to another credit card company, or to collection agencies, or to retailers who want to know who have got credit cards. They can only use that information for the purpose of which it was collected, and they have to protect that information. And so we hear things about breaches in security. So you get notified when somebody breaks into, scammers break into a commercial entity and get access to personal private information. You get notified saying, hey, your credit card information might have been found by bad actors. There was a breach in such a way. So not only do they have an obligation to only collect information that they need, only collect information and declare what the purpose of that collection is for, to only use it for that purpose, they've got an obligation to protect that information and then to notify you about that information if you want access to it or if it's been breached. So PIPEDA applies to private sector organizations across Canada that collect, use, or disclose personal information in the course of their commercial activity. The law defines a commercial activity as any particular transaction, act, or conduct in any regular course of conduct that is of a commercial character or nature, including the selling, bartering, leasing of donor memberships, fundraising lists, anything really at all. And so this is federal legislation that applies to federally regulated organizations. So we remember from yesterday, those federally regulated organizations are banks, they are airlines, they're communication companies, they are shipping companies, they're the federal government, they're federal crown corporations, and other ones that were on the list. The provinces then had the opportunity to have their own private sector privacy laws, and some of them have created their own PIPEDA legislation. Most of them have. So organizations subject to substantially or similar provincial privacy laws are generally exempt from the federal legislation. So in other words, if your province puts it in place, then you can adhere to the provincial legislation. You don't have to adhere to the federal legislation. And like the other examples I gave you today for human rights, they're almost exactly the same. Because it's all driven by the Charter of Rights and Freedoms and by the Canadian Constitution that lays out the structure and the rules of the laws, then the federal government comes along and says, we're going to create federal PIPEDA, but hey, Mr. Province, if you want to create your own, you go right ahead to make it unique to you. And so they pretty much do almost exactly the same thing. Different commissions, different processes for collecting information, different ways to make a complaint, but pretty much the same thing. So Ontario, in the final paragraph on the screen, Ontario, New Brunswick, Nova Scotia, Newfoundland, and Labrador have all adopted substantially similar legislation as the federal legislation regarding the collection, use, and disclosure of this information, but it's limited in the provincial case to health information. So in other words, the federal government came along and said, hey, all you banks, all you airlines, all you telecommunication companies, everybody's federal, you all must comply with this. And the province came along and said, we're not going to make everybody comply with this because they're provincially regulated, they're not federally regulated, but there's certain things that they thought under the Constitution should be protected, like health information. So these provinces came along with their own privacy legislation, but it really only applied to health stuff. They also came along with privacy legislation that they imposed upon government themselves that applied to everything, not only health. And they came along and applied legislation that applied to municipalities who are collecting information about your income tax and your taxes and your property and your ownership and things, and said, not only health, but everything. If you collect information on your private citizens and you're a municipality, a city, you got to comply with this. So in other words, these provinces like Ontario came along and said, not every private sector company has got an obligation to provide PIPEDA-like privacy protection for everything, but they definitely have to if it's got something to do with health information. And governments are definitely going to have to cover everything. So the examples are, instead of the federal PIPEDA legislation, Ontario has specific legislation. For example, the Information and Privacy Commissioner of Ontario enforces FIPPA, the Freedom of Information and Protection of Privacy Act. So FIPA, Freedom of Information, not only says that certain information is going to be private, but it also means that if the government has it, like government spending, they've got information about government spending, you can access that information through a process through freedom of information, access to information. So they went both ways. They said, we're going to have to protect information, but if it's in the public's interest for it to become free to the public, you can make an application to see it. So things like the Ontario Sunshine List was created. Everybody know what the Sunshine List is in Ontario? So Ontario, because all this got thought about in the courts, the government finally said, okay, everybody and anybody who earns over $100,000 is going to go on a list. And if you work for the government and you make more than 100 grand, you're going to go on the Sunshine List, and every year we'll publish that list. So they know the names of people making a lot of money. It's because they were constantly being asked under freedom of information to see how much money a politician made or a appointed civil servant made or something, or how much the union negotiated with the government. Don't keep that private, make it public. And so they have the Sunshine List. So we've got this FIPA legislation that goes both ways: protect information, but also give people an opportunity to get access to information that should be free and fair to access. And then we've got the Municipal Freedom of Information Act, which is Protection of Privacy Act. This is the one where the Ontario government says to the cities, to the municipalities, hey man, you better protect all that information. Don't let it get out. And then we've got FIPA, which is the Personal Health Information Protection Act, which is all private sector companies, organizations, and government organizations like hospitals, your doctors. They're all concerned about protecting your personal health information. So, in summary, the federal government came along with PIPEDA legislation that affected all of the federally regulated organizations. Then the provinces came along and said, do we want to play in this for the provincially regulated organizations? And most provinces said no, except for we're going to protect health information, and we're going to protect we're going to make sure that cities and towns and government entities protect your information. So here's the principles of how these things work. Number one, they need to be accountable to the public and the people by having a set of policies, practices, and procedures well documented, well established. They have to have rules, and it needs to be well established as an integral part of the organization. That becomes part of their accountability. Number two, they have to tell people why they're collecting this information. You give us this credit card information so that we can process your transaction. You give us your social insurance number so that we can identify you for the purposes of your paycheck. You give us your whatever, so you have to identify the purpose. Then you have to have consent from the person to collect it. So this is why you very often have, when you go online or you're doing something, they say, hey, you got to click here and consent that we can have this information and we can keep it and hold it. Sometimes you get those pre-recorded things where the person you talked to on the phone said, hey, before we do this, I need to get your consent. So you do it. You're going to have doctor's offices saying, hey, I can't tell your kids about your health information unless you give us a consent form that allows them to see, that they've got power of attorney, or they've assigned a consent form, a privacy consent form that allows me to tell them about your illness or about your thing. So there has to be consent. They have to limit the collection of the information to only, number two, the purpose of which it was identified for. So you can't ask them 10 questions when question 9 and 10 have nothing to do with. You can't say, and also what type of blood do you have, and also how old are you? You can't ask those questions if it doesn't have anything to do with the purpose in number two of which it was being collected for. So we have to limit the collection. We have to limit the use and disclosure of it. So once we collected that information, we can only use it now for the purpose of which it was intended. So we might have a lot of information about them, but we can't do research with that data. We can't upload it, blinding out stuff and allow the researchers to come up with averages and totals. They can only be used for the purpose of which it was intended for and what it was intended to collect and to retain. We have to make sure that the information is accurate. If we have some reason to believe that the information is not correct, we can't keep it in there. So we have to make sure it's up to date and accurate. And this is why from time to time, banks and places say, hey, you need to confirm this for us. I recently, one of my businesses, I've got a notification that I have to go into the bank with a recent tax return to prove to them that all the information on their file about me and my company is still accurate, because they never see me. It's all electronic these days. They have to provide safeguards to protect the information to make sure it can't be stolen. You have to be open to the people to let them know what information you have about them and only them, so that they can have individual access to it. And then we have to have an opportunity for people to challenge you in case you're not being compliant. So what kind of information is considered personal? Age, name, numbers, income, ethnic origins, blood types, religions, opinions, evaluations, comments, social status, employee files, credit records, loan records, medical records. All of these things happened to be private. Your province has adopted another privacy legislation, and therefore PIPEDA does not apply within that province. That is true. The PIPEDA, the federal, if you're provincially legislated and the federal government has put it in place, number one, you got to ask the question, am I federally regulated? We are not. Number two, did my province put some in place that now supersedes any of our application towards the federal, and we need only apply to the provincial one? One of these things doesn't belong. Which of the following statements about consent is false? Organizations can generally, sorry, hit the wrong button again. Organizations can generally rely on implied consent when information is likely to be considered sensitive. Okay, there is no such thing anymore as implied consent. So you've seen things in the past that don't exist anymore, where somebody would say, if we don't hear back from you by Friday, then this means that you consent to us using your shoe size in this survey. You can't do that. You have to say, give us consent to use your shoe size in this survey, assuming that your shoe size is personal and private information. The consent mechanism chosen should be clear and unambiguous. That is true. We're going to ask you for your consent, and we're going to ask you 3 specific questions. We're going to record the answers to those questions verbally on the phone. You need to say yes or no. There you go. That's a clear, chosen, unambiguous method. You need to click yes on this form. You need to sign this and send it back. You need to sign here. Whatever. So it doesn't have to only be signed. It can be clicked. It can be verbal. Most companies now record the verbal consent because it's hard to prove without recording it. Consent can be obtained in a number of different ways, such as in person, by phone, or via internet. And I just answered that question. Yes, it can be. So normally what happens is you've got a privacy commissioner, and the complaint doesn't go directly to the privacy commissioner. So unlike human rights and unlike employment standards, where you would go to the employment standards branch or you'd go to the Human Rights Commission, in the case of privacy, you're obliged to first go to the organization and say, hey, I think you screwed up with my privacy, or I'd like to see my information, or I'd like to remove my information. If that is unsuccessful, then it goes to the Privacy Commission. And unlike some of the others, the Privacy Commission wants a resolution. They're only going to provide penalties to organizations who maliciously, disrespectfully, um, negligently disregard any orders or previous orders. If somebody gets hacked and their information is stolen, the obligation is to say, hey, we got hacked and information stolen. And here's all the efforts we're taking to make sure we don't get hacked again and to try to protect this information and whatever, to notify people. They tend to not be big on punishment. They tend to be most on just coming up with a process that will force compliance. And then I'm not going to talk today. I told you we're going to finish early, so we are going to finish early. I'm not going to talk about COVID-19. There were a whole ton of privacy issues during the 3 years of COVID, that special rules were in play. But I'll only say this much. It's a perfect example of where information is collected. Did you get vaccinated? Are you experiencing any symptoms? Is there anybody in your family? Have you been in contact with any people? Have you been out of the country? There's just a whole ton of questions and collection of information that normally would not have been accepted. And yet we expressed the specific intent for which we were collecting that information and telling people how it was going to be used. And so it tended to not violate. There wasn't really a lot of charter challenges around the collection of information. There were a lot of charter challenges around, you didn't give the information, you wouldn't let me come to work. So that was more around work and privacy of information. It wasn't around the actual collection of the information. People always had the right to not answer the question. People always had the right to answer the question. They were always told that there was a specific purpose and intent and how the information was going to be collected and how it was going to be used and what it was going to be used for, that it wasn't going to be sold. And that seemed to get through there okay because it followed all the parameters of it. But the other topic that we could talk a lot about is social media. So here we are in this day when a bunch of things are happening. Number one is there are more social media platforms now today than there ever were before. We Instagram and Facebook and Twitter and LinkedIn and you name it. And it seems as though in some cases we intuitively understand, with the case of, say, for example, LinkedIn, that we're putting that information out there for the purposes of benefiting our careers or our businesses. It's supposed to help us at work or help us at our next work or something like that. And so we put information up there, and we expect that our employees are not going to be disclosing company secrets and company things on their LinkedIn profile. And very often companies, people's LinkedIn profiles are connected to a company profile that was created by the company. And I don't hear a lot of complaints about LinkedIn and privacy information. But Facebook, Instagram, Twitter, those ones for sure. Some of the other platforms like the recently made famous Signal, Telegram, Messenger, these are more like chat groups more than they are profile and information sharing places. So Facebook is a really good example, and Instagram and Twitter are really good examples where we post stuff for people to look at and see. So, some big questions. When we're hiring, is it appropriate for us to go and look at a person's Facebook profile? See what they post about, see what they like, see who they hang out with? Is it appropriate for us to use their Facebook profile or their LinkedIn profile or something to validate their resume to make sure that what they're saying on their resume is true and accurate, or at least consistent with their public persona. What if they post things about their disability? What if they post things about their religious beliefs? What if they post things about their political beliefs? What if they post information about their family or their children? So are we, is their profile public? Are we using some backdoor method to try to take a look at their profiles? And then we get people like, I think every recruitment company should have a social media policy where they ask for permission and create some standard policies about the use of, say, for example, Facebook and LinkedIn and Twitter. If you got a Facebook account, doesn't it make sense that that they might follow your company page and that they might repost a lot of the jobs that they're recruiting for on their Facebook page, so that their personality and their profile and their contacts can all forward those job postings to their friends, and that they are put onto Twitter and to groups, and that they're put into LinkedIn onto groups and into LinkedIn profiles, LinkedIn company pages and Facebook company pages. I mean, there are ways, really simple ways, to integrate automations so that a job can be posted on, say, for example, your website of your company, and you can push a button using a third-party application that will, like HubSpot or something, that you can have it automatically post in 20 or 50 or 100 different places, that it could go to every employee who's authorized it to every one of their Facebook pages, to every one of their LinkedIn pages, to every one of the Twitter accounts that they manage and participate in, to every group that they belong to on LinkedIn. And this is wonderful from a marketing and recruitment standpoint for us to get our jobs out there at a low cost. We call them aggregations, to aggregate that job posting and to put it out into 100 different places. But what if they post inappropriate content on their Facebook page in the same place that they're posting your job thing? What if they come to work and they sit at their work computer and they log into their Facebook account and they make political comments about something or somebody that could cause harm to your business's reputation? What if they get into a dispute, an angry dispute with another anonymous Facebook, Twitter, or LinkedIn user, and they start to say things that are inappropriate and that are going to be used against them in their future political career or their sales career? Where does the line stop in where you can mandate what is done on social media platforms and what is not done? And the answer is, I don't know exactly, but I do know this: have a policy. Tell people that if they're going to have an open profile that is accessible to the community, that these standards must be kept. Tell people that you expect them to do this at work, or you do not allow them to do this at work. Tell people that if they're using their phone and you pay for their phone, or you pay for their account or their internet access on their phone, what they're allowed to do or what they're not allowed to do. Use the electronic monitoring laws in Ontario to tell them they're going to be monitored on this stuff. Tell them and disclose to them they're going to be monitored on this stuff. Make them perfectly aware of what you might look at, what you might see, and what you expect as a standard in their conduct and behavior. Now, I've written hundreds of these things. I've rewritten lots of companies' policies. I've spoken at conferences about this stuff. It's a moving target. It's never what I wrote last year, I would write differently this year. Things happen that you just can't imagine or expect or anticipate. So I've got some philosophies about that. One is the broader you are, the more you cover. The more specific you are, the less you cover. So in other words, if you start to drill down and say exactly what platforms or exactly what integrations or exactly what words or topics can or cannot be used, then the presumption is that you've become so specific that anything you didn't talk about is allowed. And then you've got no case. You say, "Oh, you mentioned these 4, but you didn't mention that 5th one, so you can't, if you really meant to cover that 5th one, you should have mentioned it." So bigger picture approaches to social media in terms of policy are probably better, but being very specific about what you're allowed to monitor and what you'll allow them to do at work is better, because you are very specific about what they're allowed to do, which has the exact same effect. If you didn't mention it, they weren't allowed to do it. Okay, so you want to be really broad about the things that you restrict them to do, and you want to be very specific about the things that you will allow them to do. Because being broad about what you don't allow them to do means you don't allow them to do anything. And being very specific about what you will allow them to do means that you only allow them to do those things. Have a policy, write a policy, review the policy, get your employees to sit down and think about their policy and talk to you and engage with you in their policy. But social media, algorithms, cookies, these things are all the new breach of personal privacy that can come back and bite us in the butt from a human rights and from an employee satisfaction standpoint. Okay, so that's it for today. I want to open the floor up to allow you guys to ask any questions about the content that we talked about today. And everybody's got their mute buttons on. If you ask me something, I'd love to answer. It'll make me feel like that you're listening.
Well,
Okay.
no question, Steve. Was pretty clear.
Pretty good?
Yeah.
All right, so I can see a couple of you anyways. You're still awake, so that's always a good sign. You didn't leave and go away and come back during the presentation. My personal email address, I have lots of them, so I'll just give you the real simple one. Everything rolls up there. steve.jones@bell.net. So I've got business ones in there, but they all go to the same place. That one's the easiest one because my name's Steve Jones, so it's easy. steve.jones@bell.net. If you have any questions about the content of these presentations or presentations in the future, because I know that I think you're going to love the sales presentation, and the business practices and ethics is a great one too. Those are 2 more that you're signed up to be with me on. But any other questions, if I have the time to answer it, I will. I enjoy helping ACSESS members to deal with some of their issues. I hear some of the most thought-provoking questions from some ACSESS members on things I never even thought of before, which just shows how much different we are in the way we approach our business. So feel free at any point in time that if you request information from me, it will remain confidential. I'll reply just to you. If I think it's such a cool question that everybody should know the answer to, I'll ask for permission for me to make it generic, and then I'll provide it with your permission to Jennifer without your name mentioned at all anywhere in there, so that everybody can benefit from a good question and a good answer. And having said that, we are 6 minutes ahead of schedule. Yay. Thank you very much for participating today. Hope I didn't bore you to death, and we'll see you again real soon at our next CPC session. Oh, before we go, one last thing. 2 things. One, as an Access member, employee of an Access member company or owner or manager, you have the ability to have a user ID and password to get into the members portion of the ACSESS website, access.org. There's other resources there. And if you don't have one, you just send Jennifer an email and say, hey, how do I get access to this? She'll send you a temporary username and password. It'll be your email address and a temporary password. Then you go in there and change it in yours to have access to the member area. And number 2, we have a conference coming up in Montreal in May. It is the only national industry association conference in Canada. It is this year a Monday afternoon, all day Tuesday, and Wednesday morning. It's the only place you're going to get industry specific speakers talking about industry specific things such as sales and marketing and social media marketing and recruitment and statistics from Statistics Canada and all kinds of stuff that are only in the context of recruitment and staffing. You can spend tons of money to go to other conferences, but it's going to be generic. This is the real deal. I have not missed one in, I don't know, 40 years. I will be there. I hope that you're there too. If you're in a position to turn it into a reward or a prize or to recognize a regional manager or a leader or a branch manager to get them raising their game, this is the place to do it. It's not very expensive, and it's the best in the biz. So you can find information on that on the ACSESS website. Now, I've used up most of our finish early time, but thanks a lot, and we'll see you again real soon.
Thanks, Steve.
All right,
Thanks,
take care.
Steve.
Bye.
Thanks, Steve.